gentlemen, today we are going to discuss as to what the evidence means. Law of evidence can only be understood if you are aware of the definition of evidence. So for the purpose of comprehend the exhaustive study of the law of evidence, you must be aware of the word evidence. Society came into being, as Plato expounded, through doctrine of necessity. But Aristotle did not agree to this doctrine. He is of the opinion that it came into being on account of nature. This is the reason why he says that man is social animal. Because according to his version, the society came into being on account of nature of human beings. But this doctrine has also been falsified in the 21st century by the doctrine of rationalistic approach. In the 21st century, the rationalism adopted a different path, and according to that, the man is rational. And on account of this rationale, he collected the people as a society. So the society is based upon rationale. Whatsoever the reason of the society may be, but whenever a society is constituted on account of nature, on account of necessity, or on account of the wisdom of a man, the society has three systems. Three systems automatically emerge. Wherever, in whatever era, a society is constituted, automatically three systems are emerged. Number one is the economic system. Number two is the political system. And number three is the moral system. Every society possesses these three systems. So far as the law is concerned, it is meant to control all these systems. So for the purpose of enforcement of law, there is a need of an institution. And that institution is part of the political system. And that is known as judicial system. When we propound a judicial system, we constitute it in our own way. Every society needs to protect its economy, needs to protect the tranquility, needs to protect the peace and harmony amidst the people. So for this purpose, they constitute a judicial system. For the judicial system, there is need of a court. When we talk of a court, we mean to say that it has inherent power to do justice. Whether any statute states so much about the justice or does not state anything about the justice, it is inherent in the court to do justice. Sometimes it happens that there is no procedure provided by the law. But even then there is a court in existence working for the justice because it is inherent in the court to do justice. Now the question is as to how the justice is acquired. Now it is the fundamental duty of the court to administer justice. But how? The answer is that it is not only a court, but it is a court of adjudicature. It adjudicates upon the rights, liabilities, and the duties of the people, of its own society. So when we say this, that the court is a court of adjudicature, it means that it shall adjudicate upon. But the next question is how it will adjudicate upon? It shall adjudicate upon on the basis of judgment. Where does the judgment is created? Where is the judgment created? The judgment is created in the mind of a judge. He writes the judgment, but first it is created in his mind. Then he pronounces the judgment. The pronouncement is a later word, and the creation of judgment is the first one. But how the judgment is created? If we understand as to how the judgment is created, we shall be able to know how the justice is being given. So the judgment is pronounced on the basis of the thought which has already in existence in the mind of a judge. But how it is created? How a judge is able to form the judgment? For the purpose to make it easier, we are to define the judgment. Judgment is a statement of expression of a judge regarding the grounds of order or decree. So these are the grounds which provide the basis for the judgment. The grounds, then again a question arises, how the grounds are created? The grounds are creation of what? There are three elements of grounds. Number one, find out the fact. Number two, dig out the reality. And number three, apply the law in its true perspective. If these three grounds are available, then a judgment shall be in the mind of the judge. And when it comes to the mind of the judge, then he has the capability, rather he has the rationale to decide whether he has concluded rightly or wrongly. The determination of conclusion is a later stage, but the first one is to find out the fact, then to dig out the reality, and thereafter he is to apply the law in its true perspective. The difficulty arises when we are to see how the reality is to be taken out. That is the basic point. For this purpose, we are helpless as to how we can determine that this is real, this is not real. Because the truth is not always real. It is very strange that sometimes we say it is a truth, but it is not a reality. So the truth is not always a reality. I give you an example. You are going in a train, you will see the trees moving. I say, I have seen the trees moving. It is a truth. I am not telling a lie. Whatsoever is I am saying is a truth, that I myself saw the trees running. But the reality is that those were not running. It was the train which was moving forward. So the reality is something different, truth is something different. The witness may be telling the truth, but he might not be telling the reality. So the question to dig out the reality is the basic task for the pronouncement of judgment. But we don't have any criteria to determine as to what the reality is, what not the reality is. For this purpose, in the 21st century, modern rationalism has given the devices to find out the real reality. So that is not our topic today. Anyhow, there are 10 pillars which enable us to determine the real reality. So far as the law is concerned, we are to confine ourselves to this extent. How within the scope of law, how within the purview of law, we can determine the real reality. First of all, we have to find out the facts. How the facts are found? When one party asserts a fact, other party denies thereto, a material proposition arises therefrom. That proposition is a fact at issue. So there is not a difficult task of the judge to find out what the fact is, because both the parties confronting one another, both the parties confronting each other, both the parties who are at daggers down must be telling their own facts. So those facts are not always true, and those truths are not always the reality, and those realities are not always the real realities, and those real realities are not always the absolute realities. So the task of the judge is to reach the real reality. He should not confine himself to the fact only, because facts are being given by the parties themselves. So when the parties have given the facts, the next question will be how to adjudicate upon them, how to judge them, how to adjudge them, and how to determine that this fact is false and this fact is true, meaning thereby the fact may be false. In spite of the fact that it is a fact, it may be false. In spite of the fact that one party is asserting it as a fact, it may not be a reality. So the basic task for pronouncement of the judgment, for the administration of justice, is to find out the real reality. The question of law will come later. First question is to find out the reality. So far as the finding of the fact is concerned, it is not a difficult task. One party gives in writing that these are the facts. The other party, they know these are not the facts. So you may evaluate that he says this, he says that. So what is he and is and what is that? What is this and what is that? So this and that will give you an impression of a fact. So you will reduce it into the form and issue. Those are called the fact at issue. So it is another question, what is the difference between fact at issue and the fact in issue? So these are two, but this is not our topic today. We will do it at a later stage when we will be going through the Qanun-E-Shahadat. Okay, what is a fact at issue and what is fact in issue? But at this stage we are finding out a fact. But when we have found that it is a fact, then the next point is how to find out the reality. For this purpose, Article 18 of Qanun-E-Shahadat order, it says, evidence may be given in any suit or proceedings of the fact at issue or of a relevant fact. So it is giving us the guiding principle that how to find out a fact at issue to be the reality and how to evidence is to be given on the relevant facts. So we have got two words here. Number one, fact at issue. Number two, relevant facts. So fact at issue invites the evidence, and relevant facts help us to prove it as a fact. Now the question is as to what is relevant. In Qanun-E-Shahadat order 1984, the word relevant has not been defined. According to this law, the provisions contained therein show that all that which has been declared to be relevant is relevant. He has confined the word relevant. The word relevant has been confined therein. In fact, the relevant is wider. There are only some articles from 19 to perhaps 48, 49, they relate to the relevancy of facts. So, does it mean that these are the only relevant facts? The answer is no. We are to define the word relevant for the purpose of determining as to what fact is relevant and what fact is not relevant. This law has shortened the scope of relevancy. Why it has done so, we will discuss it later on. If it had left open the word relevant, what would have happened? But now at this stage, we are to define relevant. So, all of you being advocates must be aware of the fact that in Qanun-E-Shahadat order there is no definition of relevant. So I give you the definition. Relevant means any two facts to which it is applied are so related to each other that according to the common course of events, one either taken by itself or with other facts proves or renders probable the past, present or future existence or non-existence of the other. When we are discussing as to how the relevant facts are to be determined, then this definition should be kept in mind. But when we are studying Qanun-E-Shahadat order, then this the definition of relevant becomes irrelevant because it has given some facts as relevant. So this law is not comprehensive. It does not comprehend all those facts which can enable us to find out the real reality. Now it gives more powers to the court to itself determine as to what should be the conclusion in certain circumstances. So the duty and the powers both are correlated of the court are heavily burdened with this task because relevant has not been defined in this. So the Article 18 says evidence may be given in any suit or proceedings of the existence of a fact at issue or of a relevant fact. Fact at issue are generally the proposition which is arising between the parties. We have to resolve it through evidence. Then what the evidence is? It is very strange that evidence has not been defined in Qanun-E-Shahadat order. I am going to read it. Okay, how it says, Article 2, Article 2C, evidence includes does not mean it is defining. Evidence includes. Had there been the word means, then it would have become the definition. Definition is meant to cover its all four corners. But when we use the word include, it means that it itself is not the definition, but it is part of some other definition. There is a definition of the word evidence which is lying far away from us, and in that definition we should include it as well. So it is a species, it is a part and not the whole one. So the opening word says evidence includes. What does it include? All statements. Now another question arises, what does the statement mean? What does the statement means? It is very important to determine the question of evidence as to what the statement is. There are only 4 topics in the word. I claim that there are only 4 topics in the word. No 5th one. Number 1, God. Number 2, man. Number one, God. Number two, man. Number three, universe. Number four, rationale. These are the only four topics in the whole universe. So there is no fifth one. All topics are species of this topic. All topics are part of these topics. All essays are part of these essays. All subjects are part of these subjects. There is no fifth one. So meaning thereby that there are only four things in the universe which we are bound to understand. So when these four things are there, it is very strange that our brain is included in these four. Our brain is included in this universe. Our brain is included in all those four topics and all those things which are available, which can be perceived, which can be thought, which can be seen, which can be heard. So these are, but the brain is within them. In spite of that the brain is within them, all things are within the brain. So the brain is an authority which controls your whole system. But if there is no brain, in spite of the fact that there are four things available, even then these are absent. These will disappear before you. So we have the feelings of these things only when we have the brain, when we have the capacity to mind it. Otherwise these are not. So what happens? We get the material from the outer worlds through senses. These are five senses. If a thing relates to a thing which can be seen, it should be of the person who saw it. If a thing relates to a thing which can be perceived, it should be of the person who can perceive it. If a thing relates to a thing which can be seen, it should be of the person who saw it. So these five gates are known as five gates of knowledge. We get all things from the outer world in the inner world. So these are the source to get information from the outer world. But when we get the information from the outer world, there is another world in our brain. Three reactions may be possibly occur when we get the things from outer world. These are known as the reaction of acceptance, the reaction for rejection, the reaction for eviction. We are not going to study it in detail, but these are the three reactions. So after these three reactions, our mind starts working. And the things which coincide with it, those are acceptable to us. And when they become acceptable to us, then we have the capability to convert them into the words. So when the things are converted into the words, these become the sentences. So if I express them, whatsoever I have thought in the mind, that is my statement. So there are kinds of statements. Number one, it may be in writing, it may be verbal, and it may be through signs or visible representations. So whatsoever is in the brain, whatsoever is in the mind, if it coincides with your already hidden realities, you will convert into the words. So those words, signs, visible representations, when go to the mind of the others, they become the statements. So when we say the evidence include the statements, it means that whatsoever is in the mind of the person who is making them is depicted out. that is statement, and that is evidence. Thank you for today. Still time is there?
Yes.
Okay. Evidence include all statements. It does not exclude any kind of statement. The statement in writing, the statement by words of mouth, by visible representation, by actions, by signs. If you write on the wall, that is a statement. If you make a cartoon on the wall, that is a statement. That is speaking. If you stand before the mirror and start acting, you are making statements. So all types which are coming out of the brain and going to the others are the statements. That may be good, that may be bad, that may be right, that may be wrong, that may be false, that may be true, that may be real, that may not be the real. But what is the truth then? Whatsoever is in your mind, if that is stated, that is truth. But whatsoever is in your mind, you reserve it, you are reserving it and not depicting it and saying something else, then it is false. So the statement of mind, when depicted as it is in the mind, it is truth. And when a person is not telling whatsoever is in his mind, it is false. He is telling lie because something else is in his mind. It is true because he is stating whatsoever is in his mind. His mind is based upon perceptions, meaning thereby that in his mind there are perceptive realities, and the perceptive realities are not real realities. If the perceptive reality is real reality, then it should be equal in all the minds. But if it is not equal in all the minds, it means that it is not equal and it is not true. It is not real. And when it is not real, then how to judge what is real and what is not real? Because the task of the court is to find out the real reality. So when we come to this point, that we have perception in our minds and not the realities, then we find that there are four kinds of realities. Number one is known as phenomenal reality, and number two is known as perceptive reality, number three is known as real reality, and number four is known as absolute reality. So being a court and being an advocate, we are not concerned with phenomenal reality, and we are not concerned with perceptive reality. We have the great concern with the real reality. And we can't reach the absolute reality.